legacy. I mean, this is a man who annulled the 2017 presidential election. This is a man who just last month advised the president to dissolve parliament. Historic decisions there. How would you describe his term?
The Chief Justice term has been a mix of success and some failures, if I was to be honest. Success in the sense that he has stood firm and stood with the Constitution, and being the only Chief Justice and the only Supreme Court, in Africa, and only the third in the world to have nullified the outcome of a presidential election. I think that required some serious conviction and clarity in the mind and in the law, and he will be forever remembered and celebrated for his famous quote, for standing with the Constitution, and for his famous quote that said, election is not it's not an event. It is a process that must be complied, that the law must be complied with every single step of the way. So I think that act of bravery, he was able to breathe life into the Constitution, because never before had we imagined that a presidential election can be nullified. I think another significant highlight on C.J. Maraga's term is in the recent advisory to the president to dissolve parliament. Again, he breathed life into Article 261, sub-Article 7, which says that if Parliament fails to pass some laws that are necessary to amend the Constitution, then the Chief Justice shall advise the President, and the President shall dissolve Parliament. I think we had not imagined that we'd get the level where we get to see the Chief Justice animating the provision of that Constitution by actually rendering his advice. Those are some very brave pronouncements that the Chief Justice and the judiciary in totality have made, and we are able to say that there's hope in the judiciary, because if you look at the tenure of the first Chief Justice under the Constitution, Dr. William Mutunga, there was a perception, Grace, that an outsider would bring the necessary reforms. But you see the freshness and the energy and the vigor that the Chief Justice, who had been serving in the judiciary pre-2010, or rather pre the Constitution, actually being more bold than what you'd consider as the significant highlights in C.J. Mutunga's term. Mutunga did an excellent job, because he's actually the one who dissented when the Supreme Court was of the view that the two-third gender law be realized progressively. It is Chief Justice Mutunga that dissented and said, no, this should be progressive. But I think C.J. Maraga has extended that philosophy of independence. So I think some of the successes attributable to the CJ are actually as a result of a robust, independent, and functional judiciary. Because, Grace, you'll remember, we have a judiciary that comprises of judges that are appointed in a very competitive manner, and that do not have to look over their shoulders to see who is watching them. So that independence is what has been, is what may be attributable to the vibrancy in the judiciary, if you like.
Because you're talking about the recruitment process by the JSC there. But then again, let's take a different look at his tenure, because we've seen conflict between the judiciary and the executive. I mean, budget allocation. Remember the famous remarks by the president on we shall revisit. A lot of conflict between these two arms of government. But then I want us to look at how C.J. Maraga handled all this and how it helped in any way, or if his approach was part of the problem.
I think opinion is divided. There is reason to fault the Chief Justice's overly aggressive approach when handling interagency or intergovernmental issues. Within the order and practice of governance, Grace, the Chief Justice, when he's communicating to the head of state, who's also the head of the executive wing of government, there's need to preserve mutuality, decency, and some level of restraint. But we've seen the Chief Justice sometimes going bare knuckle and attacking the presidency in ways that are, people would find a bit unnerving and disturbing. But again, if you look at the context of the executive revisit on the judiciary, or rather the political wing of government revisiting the judiciary, you may be more sympathetic to the Chief Justice, because This parliament has been slashing judiciary budget over the years, while increasing budgetary allocations to other government entities. You may then assume that you may then suggest, somebody may argue that that is actually part of the revisit. We also saw that in the executive order number 2, the president attempted to lump the judiciary within the executive, and provided directions that touched on the judiciary, and the Chief Justice was very swift in his reaction. I think sometimes frustration with the office of by the office of the president and by parliament has sometimes triggered this kind of what we may call as, or what we may consider as excessive reaction by the Chief Justice. But a balance nonetheless needs to be found so that you preserve mutuality, courtesy, and comity between intergovernmental agencies, the executive, the judiciary, and parliament.
Let me give you a two-tier, because the JSC is yet to start the recruitment process. So does it still have time, or is it time that for the process, to commence? And also, the Constitution does not talk about an acting CJ, an acting Chief Justice. So upon the exit of Maraga, CJ Maraga, who leads the judiciary? Is it the DCJ, Philomena Mwilu?
Well, in the absence of the judiciary, I mean absence in the sense that there's a substantive office holder. In the absence of the judiciary, where there's in the absence of the Chief Justice, in the context where we have a substantive office holder, then the Deputy Chief Justice may act. That is by law. So until the term of the Chief Justice expires, and JSC, although they have not started the process of recruitment, they have time. And I don't think JSC would sleep on the job and fail to recruit in time so that it precipitates a constitutional crisis. But a matter of the matter of legal and political significance is that we have seen the JSC resisting maneuvers or external political influence, especially from the executive. When the JSC resists attempts by the president to control who becomes a judge and who doesn't, when the president refused to appoint some of the judges that the JSC nominated, JSC and LSK went to court, and I acted for LSK in that matter, where the court said the president has no role at all, and the president still has refused to appoint those judges. It may also mean that the recommendation of appointment of the Chief Justice may raise significant political challenges for the executive, and they may want to influence who becomes the Chief Justice. So because of that intended or anticipated political interference or political interest in the person of the Chief Justice ahead of the 2022 election, we may experience some delay. But if there is a delay attributable to the failure by the president to appoint the Chief Justice as recommended by the JSC, then we will resort to the court, and the court will provide an interpretation that allows for continuity. Because within the law does not anticipate a situation where there's a vacuum, a power vacuum. If, for instance, the CJ retired without a substantive office holder having been nominated by JSC and appointed by the president, then the recourse would be to the court, and the court will pronounce itself on that. I really pray that we don't get that level. But so far, there is reason to be apprehensive that the executive wing of government may want to influence the JSC's decision on who becomes the Chief Justice, and if it does not influence that decision, it may want to reject. Remember, Grace, the Law Society of Kenya and some human rights institutions, including ICJ Kenya, had previously litigated on this question when the Chief Justice, when Parliament amended the law to require JSC to forward 3 names the Chief Justice. The High Court held that is unconstitutional. JSC must forward only 1 name to the president, and the president has no role but to appoint, has no say but to appoint. Looking at the philosophy of impunity and disobedience of court orders and institution recommendations of JSC, there is reason to be apprehensive. Will the president appoint the person nominated by JSC as per the Constitution required or not?
Right.
Right now.
Okay, allow me to ask this next question, and I'll ask you to be brief because we don't have much time. What happens in the event something befalls the other 5 judges? I'm saying 5, that is assuming, the exit of CJ Maraga, because, we know about the retirement of Judge J.B. Ojwang, and the DPP has, for the longest time, been seeking to kick DCJ out of office. So as at now, upon the exit of Maraga, we'll have 5 judges remaining. So what happens if anything befalls these 5 judges? Please keep it brief, Mr. Ogola.
The Supreme Court will be crippled. That's all.
That's all.
It will
Okay. Let's talk about the former CJ, Willie Mutunga, because he did leave office 6 months before his retirement. And yes, it was a personal decision, rather. But then we've seen CJ Maraga being criticized for deliberately creating a potential crisis. Talk to us more about that.
I don't think there's a crisis. What CJ Mutunga did was his own discretion. CJ Maraga has a right to serve until the last month when he's leaving, when he's proceeding on leave. And it's about JSC. JSC should be preparing to recruit as soon as the CJ proceeds on leave. So there is no vacuum. There's no requirement in the law that the retiring Chief Justice must exit 8 months to or 6 months. There's no crisis at all. And as it is already, we have a pool of competent judges, senior lawyers, and if JSC moves with speed, because all is needed is that for JSC to advertise within 21 days. The timeline provided in the Judicial Service Act is sufficient. It's not within 30 days. JSC can actually produce a Chief Justice. So there's no crisis.
Right. Lastly, what kind of a CJ does Kenya need right now? I mean, with everything that is happening, calls for a constitution change, a referendum and all that, what kind of a CJ does Kenya need as part of your closing remarks, Mr. Ogola?
The next Chief Justice must learn to balance between law and politics. There's no two way about it. We don't need an overly libertarian judge who is overly progressive, because you see, we are going into the constitution, we are going to the election, and when you look at the role of the Supreme Court in shaping democracy in Kenya, the Supreme Court that we are going to have ahead of 2022 election must recognize that democracy is best incubated at the ballot. Democracy is not incubated in court. So if you have a Chief Justice that can balance between law and politics, then we will probably preserve this country after 2022. But if you have a Chief Justice that is fully committed to, has a purposive reading and approach to the Constitution and the law, then you can have a Chief Justice that is predisposed to nullifying election outcomes, and that can